The next case on our docket is Hamrick versus Hamrick. In this case, each party will have 50 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Do you have an amount of time you'd like to reserve at this point?
I would like to reserve 5 minutes.
Thank you. I'll be keeping track of the time up here. There's nowhere you can see it, so I'll try to remind you when you get to about a minute of your time left so you know you're running to the end of your time. The arguments are being recorded today, so number one, please speak loud so they can be, the recording can pick up your argument today. And also, if you stay behind the podium, that'll make it easier to stay in the recording for either of us to hear you today. You should not use the name of any children, minors, and victims. I don't think from the argument today you'll likely be doing that, but just in case you were to do that, please use initials and not or a term like the child rather than their actual names. We've read your briefs and are ready to proceed when you are ready.
Thank you, Your Honor. Nicole Cruz on behalf of the appellant Scott Hamrick. We are before you today challenging the trial court's judgment entry of divorce. We have served 5 assignments of error. 2 of them essentially come down to the division of property. The defendant/husband in this case is requesting that this court find that there was an abuse of discretion due to the trial court's refusal to find economic misconduct on the part of the wife. The record before this court is many examples of her misconduct, one being liquidation of funds from her retirement account while the case was pending, incurring approximately $50,000 of new debts while the case was pending. She also testified during the trial that she purchased her parents' home after her mother passed. She purchased the home from her relatives. She never traced those funds, but essentially claimed that they were somehow an inheritance. She then testified, well, I had to buy out my siblings from that. No idea where those funds came from. However, she then testified she purposely put that property into a trust account based on advice of counsel that it would prevent her husband from claiming any interest in the property. This court has established a 2-pronged test for determining economic misconduct, one being that the spouse has profited from it, and the second prong being that it was done with an intent to deprive the other of a property interest. Both of those were met here. She got the interest through this real estate, which is valued at about $107 based on the evidence that was presented during the trial, and she clearly testified, and the court did find she did that purposely to deprive him of claiming any interest in the property.
Well, she argued that this was her separate property based upon the fact that she used her separate funds to purchase this. So she wasn't just trying to protect her legal right, even though she may have been wrong in how she accomplished doing that, rather than trying to deceive husband in this particular case.
Well, she never traced that. There's no evidence that it was.
Well, and I agree. She's not even appealing that fact, so we're done with that issue. We're not appealing the fact of whether it was or was not separate. But she, as I understood, she was trying through counsel's advice to somehow protect her separate property interest.
That's not what she testified to.
Okay.
She, of course, didn't present any testimony on her own case in chief. She didn't submit anything to even try to trace a separate property interest in the house. But when asked how she acquired it, she testified she had to buy out her siblings. No idea where those funds came from, how much they were, or how that came about. All we know is that about 2 days prior to her leaving the marital residence is when she purchased the property from her siblings with an unknown source of funds, and then immediately placed it into a trust, which she testified that she established specifically so that he couldn't claim any interest in the property. And if there was correct that it was all separate property, you wouldn't have to create a trust in order to prevent commingling or anything like that. Just being in her name it wouldn't be commingling if it's not in their joint names, and as long as she has the documents, and this was within months of her filing the complaint of divorce, she would just have to present those evidence saying, this was my separate property, I used to purchase it, it's a separate property interest. You wouldn't have to create a trust in order to prevent him from asserting that interest in the property. She could have got around that if that was the case without even needing the trust. My client also presented several, it was a couple of exhibits, but it evidenced approximately $70,000 of funds that she took out of his business accounts. And what those exhibits were checks written directly from her, and she either cashed them or deposited them into her individual account rather than their No accounting of those funds was ever completed.
When you say she deposited those in her individual accounts, is there proof by way of exhibit of that, or by testimony, or how do we know that?
Both. It was, the deposit slips were included in the grouping of exhibits, and she also testified, yes, I deposited that. She is also the one that endorsed the back of the checks, which she testified to, acknowledging that those were her signatures, that she both wrote the checks to herself and or to cash, and that she is the one that either cashed or deposited them. The court didn't do anything with those funds based on testimony that my client said that he occasionally wrote checks from the account, but his testimony was very clear that he had no idea she was taking money directly from the account for anything other than business purposes or for the payment of marital bills. He had no idea the extent of the amount of checks she had written herself until after the divorce had started, and when he started digging into it, and they discovered significant debt, which she then discharged in bankruptcy, and all these missing funds from the business account. So we're requesting that this court find the trial court's decision to be abuse of discretion. We're also requesting that the court reverse the trial court's order to sell the 2 parcels of real estate. Both parties testified that they wanted to retain their residences. There's significant equity in both properties. Wife's property is all equity. There's no mortgage on it. Husband's property was about $120,000 of equity. They pretty much washed each other out. There was, I think, about a $10,000, $15,000 difference in the 2 equities. My client has no income, no other assets, no ability to obtain alternate housing. So if forced to sell the marital home, he will have nowhere to live. Versus wife who works and has an income and can at least apply for rental or potentially another loan to obtain new housing. My client won't have that option. He testified he hasn't worked in years due to the injuries to his back. He's had no income. He has no other assets other than the house to speak of that are worth of any value. He would literally have nowhere to go. And nobody requested that the houses be sold. Both parties testified they each wanted their respective homes.
Was there any other assets that existed other than the houses, primary assets to set off against the homes if the court had ordered them not to be sold?
So the wife had a 401k account.
About $10,000, as I recall.
Correct, and she had taken about $10,000 out of it to purchase a car, which was also a violation of the court's mutual restraining orders. So had the court found the economic misconduct, she could have balanced it out based off of what she did with liquidating funds out of the retirement account, incurring new debts and violations of the court's restraining orders, liquidating assets during the divorce process. I mean, the equity difference between the houses actually wasn't that much. It's about $15,000. But so that could have been balanced out with the economic misconduct finding. Husband could have retained his home, wife could have retained her home, and neither party really would have been prejudiced by it. We're also requesting that the court reverse the trial court's finding that child support arrearages be deducted from spousal support. There's no motions regarding the court asking the trial court to determine an arrearage, and there was no testimony or evidence that any arrearage exists.
There were motions for contempt for child support pending at the time of the trial?
There was motions pending by the wife. She didn't pursue those motions. She didn't present any evidence in support of those motions. Nothing was presented for the court to say, this is what the arrearages are. So we've given the wife discretion to just deduct funds that we don't know what they are, how much they were, or anything like that. So there's simply no evidence in the record to say this is what the arrearages are, or when they even went through, because the children actually both emancipated while the case was pending. So we don't know if CISA's number is even correct based on emancipation dates or anything like that, because nothing was presented saying what they were and how they were calculated. Then our 4th assignment there was as to the duration of spousal support. This is a long-term marriage, 27 years, and the court ordered about 5.3 years of support. No explanation was given, no justification was given. My client is currently 57 years old, wife is 5 years old. By the time his spousal support runs, he'll be about 60, so he won't be able to claim his Social Security benefits, or at least the full benefits. He has
And you're down to about a minute, by the way, just so you know.
1 minute, thank you. He has no retirement assets to speak of. He will have a huge gap of time before he'll be able to even collect his Social Security, so the court left him with zero protection on an extremely long-term marriage. And then finally, we're requesting that the court should have awarded attorney's fees due to the issues with discovery all throughout the case. There was, I think, about 5 motions trying to compel discovery and depositions. The court issued 3 or 4 various orders against the wife. Eventually, they were resolved just prior to trial, but that was after the filing of many, many motions, several court appearances, and several court orders just to get income information, debts, where her assets are. And that was the bulk of his attorney's fees. If you read through the exhibit showing what the actual bills and expenses were, it was primarily just trying to get discovery. I will reserve the rest of my time.
You'll have your full 5 minutes when you're ready.
Thank you.
Good morning, but may it please the court, opposing counsel. My name is Rebecca Clark, and I'm here today on behalf of the appellee, Hildegard Hamrick. In response to the appellate's brief that was filed, beginning first with the error that there was a failure to find that wife had committed financial misconduct. This court's burden then is to look at manifest weight, which tells us the court clearly lost its way and created a manifest miscarriage of justice. Opposing counsel correctly pointed out that there's a 2-prong analysis, that the wrongdoing interfered with the other spouse's property right, and that the wrongdoing resulted in a profit to the wrongdoer. In this particular case, there were 4 separate instances that they mentioned. The first is the misuse of marital funds. Husband had access to the account for the business throughout the marriage. He testified that wife was responsible to pay the bills and that he knew she was writing checks to cash out of that account to pay those bills. So it's not, for him to say now that he looks back and says, I didn't realize where all this money was going. He had full and open access. He himself admitted to writing checks to cash out of that same account, and he gave wife the responsibility of paying the bills out of that account. Second part, when we talk about that same failure.
Now, there's some indication from counsel today that there are exhibits showing those funds going from this business account, I'll call it, to wife's account to pay debt. Is that correct? Is there exhibits showing it going into wife's account?
I do believe there are, Your Honor, but again, there's no evidence that those weren't subsequently removed from that account to pay bills. There's no allegation that wife had a $50,000 separate savings account that she was keeping separate from the marriage. The allegation is that she moved funds around, absolutely, but in order to pay those bills. Counsel brings up the fact that discovery had to be requested over and over. In part, the records that wife wanted to use to prove where the money had gone were sequestered within the marital home, to which she was denied access. She filed a motion to get access to those records and to the marital home, and that was never ruled upon. So whereas husband says all of this money was removed and that wife removed it, when she then sought access to get those records to show what had happened, he denied her access to the marital home. She had to file a motion to get access, and that was never ruled upon. The second part of the allegations in this financial misconduct had to do with concealment of the Dennis Lane property, how it was purchased, things of that nature. As this court is aware, irresponsible financial decisions and even dishonest financial behavior does not in and of itself constitute financial misconduct. In this case, just as husband claimed that the Claremont property was his separate property, but failed to prove that at trial, wife made the same claim that the Dennis Lane property was separate property by inheritance. She also didn't prove it at trial. She didn't prove any documentary evidence. So by the same action he took, which was that he just testified on his own, she testified on her own, and at the end of the day, the court found that neither one of them met that burden, and that the property should be sold, and the profits evenly divided. Wife didn't commit financial misconduct by not proving her case. She suffered the consequence of the property being declared marital and being sold with the equity to be divided. In her discovery, she turned over a copy of the trust where that property was listed. So again, she didn't try to conceal what happened. She attempted to, as this court pointed out, attempted to provide evidence or create evidence that this was separate property. Her failure to do so ultimately leads to the property being sold. Mutual restraining order doesn't prohibit either party from incurring debt in their own name. There was no joint debt incurred. It was a debt in her own name. She never claimed it was marital, and in fact ended up filing bankruptcy on her own because she couldn't make that payment. The same is true for the 401k loan. While that is a violation of the mutual restraining order, it was a loan, not a straight withdrawal. So it was in repayment, and the court's decision to just include that loan as the full amount of equity to be divided at the time of retirement or at the time of the divorce means that he suffered no consequence for her having taken that loan. As this court's aware, she filed multiple motions about failure to pay child support. So a husband put her in a position where she had to incur some debt to pay her bills, and then wants to claim later that that was misconduct on her part. So when we talk about husband, it was found by this court that husband had the ability to work. So whereas husband would have this court believe that he doesn't have the finances to obtain separate property, that he doesn't have the finances to do anything, it is of his own decision to not work, rather than a.
Did the trial court find he could work, or just that he couldn't prove he could not work?
They didn't find any evidence that he couldn't work, is how it was phrased. So
That was my recollection, not a specific finding that he could work, just he hasn't proved he's unable. I just want to make sure I understood the findings.
Yes, correct. So then the second error, which they talk about, is the misclassification of all property as marital, right? The Claremont residence, the Dens Lane residence. He couldn't prove his case any better than she could prove hers. And so while she failed to provide any documentation, the court did what the court should do, which is to equitably divide. So I understand that husband is upset with the fact that the court ordered the properties to be sold, but when you're looking at the court's broad discretion to be equitable, that's the easiest thing to do. It's to just order the property sold and any equity to be divided. If husband wanted to retain that property or to balance assets or anything, he had every opportunity to settle this case. He had every opportunity through counsel to make those recommendations and to seek that in a separate settlement rather than sending it to trial and allowing the court to make their decision.
Did your client at trial object to selling the properties?
Your Honor, honestly, I don't know.
You don't know if she requested it?
No, so I apologize. I don't know if on the record she objected. I know that both parties believed it to be their separate property and both parties thought they would be able to retain their homes. But again, their failure to prove that at trial just leads to the easy outcome of an equitable division of property.
Are the homes sold now?
Your Honor, I don't know. The third error was in deducting child support arrearages. Again, wife had filed multiple motions asking that that husband be held in contempt for failure to pay child support. So there was already an argument there. Whether or not she pursued that at trial, the argument was in favor of the court. And the court is a court of law and equity, right? It can see that whereas he didn't pay child support, that those funds should be deducted then from her spousal support award to him. As to the duration of spousal support, there's an argument that it should have been indefinite, and also that this court erred in that the trial court erred when making the decision that it would terminate if husband remarried. There is nothing that says the court has to do anything. There is no requirement in the law that spousal support terminate upon remarriage. There is no requirement within the law that indefinite happens every time. These are both case-by-case decisions with a court that has broad discretion. So in order to prevail, husband would have to prove that there was an abuse of discretion, that this court clearly lost its way and made some decision that made a decision that wasn't fair. And in this case, this was again taken in by evidence. They put all of this before the court rather than settling this on their own. They allowed the court to make the decision. And so that's a risk we run, is that when the court takes in the evidence, that they use their discretion. As to attorney's fees, there were multiple delays by husband. His counsel withdrew on the day before the first trial, which subsequently delayed the trial. He also filed a motion to disqualify wife's counsel, which took 5 months to be heard because of other continuances by the guardian ad litem. Those are just husband's moves. Also, discovery. He makes multiple motions for discovery, and at the end of the day, he files an entry that says that those matters have been resolved. So he doesn't even pursue a trial that he didn't get the appropriate discovery. This case is also complicated by the fact that wife ended up filing bankruptcy, which she's entitled to do, and especially given her financial circumstances needed to do. There was the COVID delay. We had a global pandemic, and so this case was ultimately delayed by those court hearings being moved. And third, we had the death of 2 judges who presided over this case. That's almost unheard of, to have both the presiding judge and then also a visiting judge to whom the responsibility is given, to both have them die during the proceedings. So the fact that this case has sat and gone through all of these proceedings and all, was not by one party's actions. It was by both parties filing their own volume of motions, but then also by just the fact that this case sat underneath a global pandemic with the death of 2 judges. So the court did not err in not awarding attorney's fees. Certainly that was within their discretion. Also, husband didn't bring to the trial anybody who testifies to the reasonableness of fees. So while counsel testifies today that the bulk of the fees incurred were because of wife's actions, there was no one there to testify to that fact. So had they even pursued it, they would not have been able to meet their evidentiary burden. Ultimately, the appellee is asking this court to affirm the decisions made by the trial court. Given all the facts and information provided before the court, it used its own broad discretion to find equity, right? And it's not in the way that either party would have wanted, without any hesitation. I'm sure that both parties would have liked to retain their homes as separate property, or both parties would have liked to have some say in the final division. However, they lost that opportunity when they went to trial, rather than settling this case at any point in the 5 years that it was pending. They had that opportunity and they gave it up. So the appellee asks this court to affirm the decisions of the trial court.
Counsel, on assignment of error number 3 in the issue of the child support,
Absolutely.
was there any kind of pending motion from, I'll say wife in this case, I believe she was a plaintiff, but
Sure.
I know she moved for contempt. Had she moved for any kind of decision about temporary support, arrears, or setting any kind of judgment as to those?
I don't think that she asked it to be reduced to judgment. I think that in her motions to show cause, they were as to the temporary order, but I don't think that she moved to have that reduced to judgment at any point.
Since we don't have a specific number in this case, let's say CSCA said it's $10,000 and father disagreed with that number, or husband disagreed. How will he challenge that now?
So there was a temporary order which gave a specific amount per month, and there was testimony as to whether or not he paid that. He testified he did not, that he didn't work, that he hadn't worked, and that he didn't pay that child support. So a very simple calculation can tell you what it was through the term of the temporary orders, what that number should have been, and then what wasn't paid. So I don't think that CSCA's hand calculation was overly complicated by maybe payments made one way and then not made certain months and things like that. He never testified that.
Well, I don't know that it'll be complicated or not. I mean, I'm sure they keep these records in the normal course of their business, and they're going to say it's X, Y, or Z. But let's say in this case, father says that's not the right amount. I think it's $2,000 less. What is the remedy going forward to challenge that?
I think he should have challenged it at the time of trial. If he believed that he had paid a certain amount, that he should have been testifying as to what he paid, so that the calculation could have been done to include credit for money spent.
But unfortunately, there was no presentation then of what that number was, or how would he know to complain about it then?
Again, Your Honor, I don't know that, given that there was a temporary order with a specific amount, if he made any payments, he should have been testifying to those payments to prevent this court from issuing an entry that didn't have a specific number, or even a specific number that was proposed by child support. Again, this court asked CSCA to do a hand calculation and then to impose that. Whether or not there would be an opportunity within that hand calculation to seek, or, you know what I mean, redress, that I don't know. I don't know if he could have brought that to the trial court on a 60B or something of that nature to say that there was a mistake, some kind of neglect or an excusable mistake.
Thank you.
Thank you, Your Honor.
And you'll have your full 5 minutes.
Thank you. I'd just like to address some of the statements of counsel. First being wife's request for access to the marital home. That request was to obtain personal property that she had left behind. It had nothing to do with discovery. It had nothing to do with requests for business records. It was simply so that she could get items that she had left behind. The trust document also, yes, the trust document was provided. It doesn't identify what is held in the trust, what assets it holds, or anything like that. It's just the trust is created for this purpose. This is the beneficiary, and the trustee and subsequent beneficiaries. There's nothing in that document that says this is what the trust holds or where those assets are located. So than the fact that a trust existed, she didn't produce anything saying this is what's titled to my trust. As far as the motions for contempt as to child support, I think counsel is asking this court to shift the burden to my client to disprove arrearages that are never proven. If there's nothing in front of the court saying an order's been violated, why would the court assume it's been violated? No evidence was presented saying this is the arrearages, this is what payments were missed or made or whatnot. The court has literally nothing to go on to say it hasn't been complied with other than the fact that a motion was pending. But that doesn't mean anything. It's the moving party's burden to show that the motion has merit, that someone is in contempt, that the court order's been violated. That didn't happen. The court just assumed there must have been a violation, therefore we're going to task somebody else to determine the amount of arrearages, and no one has any ability to challenge it or argue against it. That's an abuse of discretion. It's extremely prejudicial to my client, and we ask that you determine that to be an abuse of discretion. Also, as to the incurring of attorney's fees, there were attempts to settle this case, and at every request, wife's position was let the court decide. We'll let the court decide. Even before we started trial, the day of trial, the judge said, everyone take time, see if you can get it resolved, as they always do in every case. And wife's position was, nope, let the court decide. The court then asked her, present your case, and she said, I don't have anything, I just want you to decide. And that's on the record. So, yes, he could have presented that to wife. Offers were made to wife. Nothing was reciprocated or discussed in settlement that led anywhere, because her position the whole time was, I'm not represented, I'll just let the court determine what will happen. And now we're here. And as far as attorney's fees, very interesting. The judge decided that she doesn't allow attorneys to testify to their own fees, which was the first time I had experienced that. I attempted to call myself, at which point the judge said, no, I don't let attorneys testify as to their own fees. You have to call in a separate attorney to testify to the reasonableness of your fees. Had no prior knowledge of that or notice of that, and I was listed on the witness list to testify as to fees. However, my client did testify as to the fees. He testified that he doesn't have the ability to pay them. He testified as to why they were incurred, and he did identify the billing statement. Wife also stipulated to the bills being submitted as exhibits at the trial. So the bills are there. The court could have easily looked at them and said whether she thought they were reasonable or not, which the court is tasked to do when they're presented anyway. And all of the services are listed out. Preparing motions to compel, good faith letters, hearings on the motion to compel. It's all there, so it explains exactly what happened, how much time was spent, and what was incurred. The court could have very easily weaned it out if she didn't think certain expenses were necessary, which is what the trial courts always do when they go through fees. They try to get it down to what they think would be fair and reasonable based on the circumstances. But in this case, the court just didn't weigh any of those. She said they were both represented by attorneys at different points, and therefore they should each pay their own fees. Were there delays caused by wife? Yes. Were there delays caused by outside sources that had nothing to do with her? Yes, 100%. We're not blaming her for the pandemic or the transferring of judges or anything like that. But the record is clear. Trial was set at various times. Trial was then canceled on the day of, and the court put on new orders that day saying, send over your discovery responses. Counsel doesn't deny that. She doesn't deny that that court order existed, saying case called for trial, trial canceled and continued due to discovery issues, and then wife was ordered to submit her exhibits.
And I'll note your rebuttal time is up. You may briefly conclude.
Thank you. We just ask that you sustain the assignments of error and reverse the trial court's judgment entry. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter on advisement and will issue a decision in due course. The clerk of court will mail a copy of that decision to you when it's made and when it's released, and the opinion will also be listed on the Supreme Court website. Thank you both for your time.